I'm Lewis Hatcher. I'm an employment lawyer with Watson Spence, or primarily my practice is focused in the area of employment law and other federal court litigation. What I want to talk to you about today was in the employment law arena, with a depressed economy, or anytime there's a downtick in the economy, we'll see an increasing number of lawsuits filed by employees who are disgruntled either with working conditions or with the fact that they've been demoted or terminated. Most lawsuits that we see are those involving termination of an employee. We also have been told, although I don't have confirmation of this, that the EEOC is now giving its agents bonuses for finding that there has been a reasonable cause to believe that a violation of the federal employment laws have been committed, and so that is particularly disturbing for one who does defend employers, because it's going to make the number of lawsuits filed increase, I believe, exponentially, unfortunately. There's really no disincentive for an employee to file a lawsuit against an employer. For the most part, employment lawsuits on behalf of plaintiffs are handled on a contingency fee basis. In other words, the lawyer agrees to donate their time to the case, and then they will get a recovery on their attorney's fees only if there's an award by the court or by way of settlement to the plaintiff. The plaintiff does, under the ethics rules of the Georgia Bar, remain responsible for costs of the lawsuit, but that does not include attorney's fees. And the plaintiff has really a very limited investment of time or therefore money in these lawsuits. On the other hand, the employer is at a big disadvantage in employment lawsuits, because most of the federal laws provide that if the plaintiff wins, not only is the plaintiff awarded whatever judgment is awarded by the court or by way of the jury verdict, but the employer will also be responsible for the plaintiff's attorney's fees, which can amount to several $100,000. In addition, the plaintiff, if the plaintiff loses the lawsuit, the plaintiff, except in extremely rare circumstances, is not responsible for the employer's attorney's fees. In other words, an employer can successfully defend against an employment lawsuit and be out several $100,000 worth of attorney's fees and get a victory. But that's sometimes a small victory when you've paid that kind of money to defend yourself. It's not necessarily advantageous for the employer, though, to settle cases to avoid litigation expenses, because that is going to encourage other employees to follow suit and try to get some settlements themselves. The best approach is, in my opinion, is a good training program, good strong policies and procedures on the part of the employer. In fact, the employer is allowed to offer a defense in those cases where the person claims to be a victim only of harassment, say sexual harassment or racial harassment in the workplace, so long as the employer had strong policies in place. They were clearly articulated to the employees. The employees were encouraged to come forward with complaints if they had complaints, and either the employee did not follow that procedure, did not complain through the proper channels, or if the employer took action to correct the harassing conduct as soon as it was brought to the employer's attention, then the employer can avoid liability most times in those cases. That's not true if there's adverse action such as termination of the employee or demotion. For more information, you can contact me, Lewis Hatcher, at Watson Spence. You can either call me 229-436-1573, or our email address, my email address, lhatcher, Hatcher, @watsonspence.com. Thank you.